very good evening, good afternoon, good morning, depending on where and when you're watching us from. My name is Mutathi wa Shirawanyaga, Mujiro wa Baria Karigi. Hoka kumango shotheria ciumaga huho. Muri thayo. Today is a good day, is the 5th day of the month of June 2024, and we are back here on African Corner, episode 48. And today we'll be talking about another topic, another conversation that we have here tonight, which is basically decolonizing legal frameworks. We want to talk about issues, law issues, legal matters, especially in the Afrocentric kind of perspective. We want to understand how do Africans view these things. And tonight we have Grace Mureithi, who's a law student finalist, and she has also so many other accolades in her name. I don't know why she's trying to be humble, but maybe she will want to share more with us tonight as we are going on. And I can see people like Fred Monkonga already saying this is the moment I've been waiting for. So Grace, people have been waiting for us for some time, and I hope they will learn a thing or two. So Grace, maybe you can also introduce yourself, tell us what you do. You're not new here, so some people have seen you around these circles. So you can introduce yourself, and so that we can be able to go into the topic of tonight.
Thank you so much, Washira. I'm so glad to be here. Apologies for the people who are waiting. We had a small technical hitch, but I'm glad we're here. So thank you once again. Yes, my name is Grace Mureithi. I'm currently in my final year. The accolades Washira is talking about, he better tell me about them. But in a nutshell, I can say that I'm passionate about community development. I'm passionate about leadership in general. I am in the Kenya Model United Nations Club in my school, and a coordinator of the African Youth Leadership Forum also in my school. And yes, you will see me somewhere in the corridors of justice, or even just somewhere near you. But thank you so much. I'm so excited about this topic today, and it's a good one. It will be a good one, this one.
Thank you, Grace, for being here and honoring the invitation. So let us get into it. Maybe there's somebody who is watching this live or will watch this later and does not even understand when you talk about legal frameworks. Maybe you can just generally, tell us about what is legal frameworks. When we talk of the term legal frameworks, what do we mean?
Thank you. Yes. So in layman, legal framework is the things that have been set, or the set of rules that have been put down to govern a nation, to govern people. And what we have as Kenya, basic legal framework is, of course, the Constitution. That's the new Constitution, 2010. That's what we keep referring to. But legal framework really are formed by policies and rules and regulations. Yes, but as Kenya, that's our basic structure.
Okay. And because we are calling the topic of tonight decolonizing legal frameworks, do you want to say that our legal frameworks are not really decolonized? They are still colonized in a manner? Because let us look at it generally. Generally speaking, because you're also talking about the Afrocentric approach to law. How do you think Africans have been viewing law and the legal framework that they are there, and even Kenyans to be specific? What have been the views there? You as a student of law, what has been the issue there?
Thank you. So yes, we are still not there where our laws have been decolonized, and I think we have come to a process. So when you talk about decolonization, what do we basically mean? We mean that laws, we should think about reshaping our laws and principles and just re-strategizing and seeing that they do not have a Eurocentric meaning that the Europeans are the ones who colonized us, and we should rather have an Afrocentric point of view or law structures. So yes, we are not there yet, but when you look at, for example, when we were colonized, when the Brits came, they found a very decentralized system for the traditional setups. They had the Council of Elders. So at that point, we can say that there was colonization, yes. And when we were heading to independence, something happened. it's where now they reconsidered, okay, let's not just use the Eurocentric approach, that's the colonizers approach only, let's see how we can integrate them, right? So we moved from fully colonized to them saying, let's reintegrate now the traditional setup and now our modern legal framework, which is now the colonization. So you can see we have not really moved from the colonization part. What they did is integrated. And then look at those two. There are two things that come from that. You have codification. It can be codified, number one, or we can do what is called a restatement. So codification means that these traditional rules that we found, whether it's marriage, when the Gikuyu culture wants to get married, or sorry, or there is a succession laws, or getting land, it means that you find that these laws, for example, we see like Belgium, France have taken to have this approach whereby the codification occurs when these laws are brought into one place and written down, and they form like the structure that is gonna be used by courts. But here's the danger. What happens is, Washira, you and I know that the moment we write things down, it washes away like everything. We cannot start saying Agikuyu culture practices this, Jaluo culture practices this, and everything. We know how rich and wealthy our culture is. So the codification part is used as a guideline, and
Okay, I think we've lost Grace there. So with some network issues, let's see if she'll be able to come back in a few minutes. I don't know. I'll give a few minutes to see if she can be able to connect. But I can see some comments coming in here. Fred Bonkongo is saying that, Grace, I am the one who serves tea here. Welcome to the official African channel, the home of untold African stories. And then Fred Bonkongo, Jeff Miner is talking to you and saying anza kuleta chai na mkate before iongezeke bei. And Gilbert Stark is also here saying, as of today, colonization is a political accusation.
can you hear me?
Then Redwell Congo says that Jeff Miner, you are fined in the last session. Please first clear
Could
the
you hear
accounts
me,
before attacking me.
Washira?
Yeah. Oh, Grace, you're back. We can hear you now. Please go ahead.
Hello, can you hear me?
Yes, Grace, we can hear you. You can proceed.
Okay. So sorry for that. So what I was saying is that you'll find that, yes, we have integrated, fine, but when you go before that judge, they don't know that culture very well, you know? They don't have the experience of it. So that is why you find that sometimes they refer to a system called ADR, that is Alternative Dispute Resolution Method. We have like mediation, arbitration, negotiation, where now those people who are who know the law very well, and they know especially the traditional methods, the resolutions, and how to use them very well, they can now take over the matter. That is codification. Then we have restatement. That means that this one, we're not codifying the laws in one place. This one, we're just having small structures or small guidelines. For example, we can say if someone is getting married, or for example, if like FGM is not allowed, like the constitution talks about, the traditional customary law can also be upheld so long as it's not repugnant to justice and morality. So long as it follows the right structure, it is okay, right? And FGM, of course, rules out that. But you see, that one has not covered culture to culture. That's just a guideline. So for the statement, you find that it's more of a guideline, and they do not use it very straightforwardly, but those are the two types where this integration happens. So it's not completely Afrocentric, but at least it's somewhere close. At least there's consideration, because the Constitution also talks about a customary law being a source of law. So yes.
Mhm. So basically, what you're saying is that there are some certain strategies that are being employed to incorporate indigenous knowledge into the legal systems. And do you think
Yeah,
they're efficient? Are they really, really efficient in the Afrocentric perspective?
I would like to say so. To be very honest, they're not really. They're efficient because we can see there are cases that have already been decided,
Mhm,
because of that, and you can see you very well a judge has chosen to take the approach of customary law,
mhm,
where you say, oh, this is a tradition, this is what you're using, and this is what you think about land and marriage. They choose to take that approach. However, we cannot say that it has fully integrated, because at the end of the day, we say that justice has to be served, and maybe that part of justice in terms of traditional method does not really acquaint well. So
mhm.
we are not yet there. I would like to say we are not yet there, but at least they're being considered. But we
Yeah,
have
because
cases that
what,
are.
what I remember is that there's some time back, I was reading on the 1994 genocide that was in Rwanda. One of the ways that they were trying to settle those disputes is to use their traditional ways of, settling disputes, and I think it really worked well for them because it even fastened the issue. So that's quite interesting to hear, because I think many people think that the legal system is purely Eurocentric, and sometimes it doesn't fit the Afrocentric perspective, because the only people who have their own way of doing it is the Muslims, who have the Catholic coast. Uh, anyway, so let us move on, and but you see, there is somebody. I had somebody saying, do even the lawyers themselves and the student lawyers, the people who are going to become lawyers at the end of the day, think of these things in an Afrocentric manner? Will you say so? That you really consider that, the fact that we are going to practice law in Africa and we are Africans, do do you think it is really considered by your fellow students, lawyers, and is it even in the system in the first place? Does your education system allow you to do that?
That's a very good question, actually. And I must say that when you sent me, when I got to decide about this topic, it was something far-fetched. You get what I'm saying? It was something,
Mhm.
oh, okay. By the way, it was more of like, you have been immersed into so much modern legal framework, and this one, and I'm glad that we're having this conversation. So we do not see most of this, and yes,
Mhm.
it is in our legal framework and what we learn in our course outline. For example, the Succession Act, it gives procedures on how, if there's a dispute of land, or there's a dispute that is should be decided, you find that there's a cap where it can refer you to people who are more who are more knowledgeable, experts in that area. However,
Mhm.
Bashira, to answer your question, it's we're in a place where we are living as a consequence of our culture, which means that the consequence of our culture right now is modernization. That means the approach that is coming, we are seeing summits, we are seeing conferences that are trying to incorporate this Afrocentric. However, there's much in class. We do learn that, and we do actually learn about TDRMs, traditional dispute resolution methods. Yes, we are learning even the whatever you said, the Gashasha courts in Rwanda. That is one thing I can tell you. We learned for sure. We saw the pros and cons.
Mhm.
But however, it's one thing to learn and to theorize, and it's another thing to actually practice it.
Yeah, and
Because when
that's
you
what
go.
I want to ask. Is there any practice that are people really practicing this? Because somebody was telling me, you see, when you go there, ask Grace, why 60 years after independence, why do the lawyers and the judges forced to wear this white thing you wear on your head. And what's the reason? Because it's very Eurocentric. Some of us don't even know why you do that in the first place. And you are seeing the former Chief Justice, that is Chief Justice Mutunga, who was like reducing this, in the court. But now when Maraga came, there was changes again. So what about that?
Interesting. We have to say law is a very noble cause and profession to say. And the first time I entered to law school, that was resounding. That was something that it entered, and we were very sure that we were looking towards the English, the England courts. Because now you see, us we use common law, and common law is decided by the who? The Brits, the England. So that means every decision that is made in court, we refer to the cases that were already decided in England. So you find that most mannerisms, or most even the career and just the profession and most of the things that happens, the fashion that happens, it's just coming from there. So when it comes to that wig, that wig is like 40,000, or I don't know how much is it. I don't know. Correct me if I'm wrong, but it's expensive to start with, And we have a chief elder in Meru, Njorinjeke, who actually solves so many cases, and they're mediators in their societies, and they do so much. And you can see they bring, it's called restorative justice that is more reconciliation focused. People get to have peace harmoniously. So it's something to think about. But that one tells you that we are still in the Eurocentric. People still want to be associated with the prestigious of lawyering, and yeah. So that's what I'd say.
Yeah, the English sort of, because I did not even expect that thing to be like 40,000. Oh my goodness! Because now and why, people should be asking themselves why is this the case anyway? So what we are saying basically is that there's been less of decolonization in the legal process and the legal framework in this country. And now let us even talk about the 2010 constitution. Okay, these days we cannot call it the new constitution. It is like 14 years old almost. So it is not that new. So let us talk about this 2010 constitution. Do you think that the traditional African systems, the Afrocentric system now in the Kenyan setup, were inculcated? Because now we want to know what is the role that these traditional systems play in modern structures, because at the end of the day we are still Africans, and we are still influenced, and the issues that are happening in the ground, kwa ground mambo ni different, the African issues are happening. So sometimes we need to solve these issues in an African way, in an African setup. So do you think these traditional systems were inculcated when they were bringing in this new legal framework, the Constitution of 2010?
Thank you for that question. So they were, but I can talk about two clauses for the Constitution, and one of them is what I had mentioned earlier. The Constitution talks about customary law being a source of law. So that means citizens, judges, lawyer practitioners can go back to customary law and use it as a source, right? But now this source of law, it's not codified. It's not written in you see. So it is one thing to write. So we should think about the policies that are already there, and they're not well. For example, you'll find that there's no clear definition of customary law, for example. In Nigeria, Nigeria attempts to define, like in depth, like what customary law is in terms of the traditional practices, but you find that there's no serious attempting of like trying to debunk this thing, the traditional practice. Then we have the second one, which is it should not be repugnant to morality and justice. It should not be against morality and justice. And I don't know whether you remember the case where the people from the central, the Mount Kenya region, where Changa was being viewed as illegal brewery, when it's just they were saying it's just a traditional form of
Moratina, the issue of the Moratina, they said it is no longer illegal. And you are wondering, was it illegal in the first place?
Moratina, yeah. So you see, it wasn't, because it's their culture. You see, that some would argue it's their culture, and that's why they took it to the forefront. So you find that it's almost like trying to fight, trying to back and forth. So I wouldn't say it has tried, but now the implementation part of it, we always go back to the common law, and that is Eurocentric. And that is now England, because now it's like it's the one that has set precedent. Yeah.
Yeah, I can see Gilbert Stark saying, Washira, kindly ask Grace what type of democracy do we have and use in Kenya?
Sorry?
He says, what type of democracy do we have and use in Kenya? Maybe you can respond to that before we proceed.
Okay. Thank you, Gilbert. Thank you, Gilbert, for that. So the democracy that we have right now, I'd say is okay, there's a practical part, and there's what we talk about, rule of the people, for the people, by the people. So I don't know whether we're here to talk about, is it really democracy, or I don't know, but just know we are just following democracy in that it should have the elements of open accountability, the rule of law. It should have the elements of open honesty, transparency. So I don't know how practical it is. To be honest, it's not really practical. I think we get to practice democracy like after 5 years during elections for most citizens, but definitely we should have more public participation processes. So yeah.
Okay, so I thank you for responding to that. And Grace, what you're saying is what I'm hearing from you is basically that our legal frameworks, as they are at the moment, they are really not inculcating, they're really not embracing the Afrocentric, ways of life, except the customary, and the customary ones, they are not codified, they are not explained, they are not even considered in jurisprudence, all that. So let us get into some specific issues, like, for example, the land rights, on the land cases that we see here in Kenya, for example. It is just too much. And we ask ourselves, when does the legal systems, now you being somebody who understands these processes, do they really consider this Afrocentric way? Basically, even not only the land issues, but the issues in general. Do the judges really consider issues emanating from the excuse me, from the Afrocentric way of thinking, or they just, this is the law is as it is, and that's it?
Yeah, thank you. I think that's a very good question. So we have, for example, when you look at our education system, it tries to bring a curriculum reform in terms of, it will include African legal traditions, philosophies, case studies. You learn case studies in law school, in Kenyan universities. It can offer specialized courses on Africa customary law and its application, right? Because if I'm a law student, and if someone is, for example, political science students, those ones are the ones that are going maybe to get the opportunity to learn in depth about this customary law. So number one, you have curriculum reform, definitely. So that's in the education sector. And also, of course, the research that is there, the scholarship, we find that Africans are more encouraged to research on Afrocentric legal practices and their impact in actually contemporary legal issues. You find that there's funding and support of centers or research centers that are focused on African legal study. So when we talk about like the education center, you find that there's an attempt to do that. No, when you look at our governance now, the system, there's a system of devolution whereby most of the funds they are put into two, the national and the Senate and the county. So you find that it there's also the affirmative action. So there's a sort of like moving into the Afrocentric, but I would like us to understand that it cannot coexist on its own. They cannot be it can only be an integration, and that's where we are at. It cannot really coexist on its own, or we can say we have fully reached at a point where we are an Afrocentric legal system. That is for sure. I think since we were colonized, we can only try to decolonize ourselves, but we cannot reach at a point where all the cases and all the in the corridors of justice, all the case studies, they are being referred to traditional reforms or traditional methods. I think it's a milestone to actually reach there, and it's hard because we are actually modernizing and we're moving to a different thing. So we also have the cultural, we also have alternative dispute resolution methods. So in court you find that there's a backlog of cases, right? And when there's a backlog of cases, it means that not all cases can be covered. Like we have so many cases at once, thousands of cases that have not been dealt for like over 10 years. And especially what you're saying about land cases can stay even for 20 years. And maybe if there's someone who is in that browser who can even solve that, but then because of maybe conflict of interest, people want to go that way of the court. But Rashida, we need to understand that it is more binding, or we find that the litigation way or the court way, sometimes it's more binding. You understand? Like when someone gives an outcome or says a judgment or gives you a judgment, we can say it can be executed. But sometimes for like the traditional methods, sometimes it's not binding. You might say, okay, we have said do not cross this land, this is not your land, but afterwards there's no accountability to it. So as much as the Afrocentric way is it's more diverse, it's what we really would like to be associated with, it also has its pros and cons right now. So yeah.
Yeah. Okay, I hear you. I hear you, Grace. That makes a lot of sense. But now let us now look at it on the other side, because we have been talking about how the law has been, is it embracing the Africans and the Afrocentric way of life. So let us now look at it on the other side. Do the Africans now, or how are Africans embracing and looking at this law, the laws that are there, basically Eurocentric laws, because it's something that the precedents that have been set are from, as you have said, from Britain, from England and whatever. So how, do you think so far the Africans, especially we as Kenyans here, have embraced the law the way it is? Or do you think as of today we see it as a very foreign aspect, as a very abstract and foreign thing?
Okay, that's a good question. So here's the thing, and I think I noticed that when I did my attachment at court, and you find these cases, you find so many citizens, they don't know the process, they don't have the knowledge, they don't know what to do. It's so far-fetched. It's like okay, I have a case. I need my land to be solved. There's an assault issue, there's a land issue, very issue. But how do I go through? You find the people who are so green, and unfortunately that's how they fall under the fangs of these lawyers who aren't lawyers. So what I noticed is that what I noticed is that you find that unfortunately there's no legal awareness. For you and me, we know, and that's why we are having this conversation, right? But let me tell you, when you get outside here and you just talk to someone and tell them, even when you ask them a question, they might even think you're from DCI, or even you don't want to.
Okay. Apart from the awareness in itself, Grace, apart from the
Yeah.
awareness, even if they are aware, for even the people who are aware, or even the people who are unaware and they still become aware, do you think they embrace it really? Or they still look at it as very foreign. This is not, I don't think it is from within. And come to think of it, we are in a more modern time. Think of people who are like in the 70s and the 60s. How was it for them?
Yeah, okay, I think I understand. So people have not yet come to that acceptance, and you find that, okay, I know this is the law, this is what is
Mhm.
coming, there's this modernization, and there's what I was taught at home by my grandmother, for example, where I grew up. So there are two conflicting ideas, and there are two conflicting source of laws, or how I would define as the methods that you're using.
Mm,
But then you find, for most people, people have embraced it, but when into practice, for example, there's dowry in Kenya, the ratio. There's a civil marriage. People will get married in church, but they'll still, before that, they'll go to that ratio wedding and make sure they've done that process well. So they have seen it, but they know the importance. They still know the importance of doing some of these cultures or following some
yeah.
of these uh, legal frameworks. So whether they're aware or not, I think we're at a point where uh, people are getting to embrace it more. Yeah, people are getting
Mm,
to embrace it more, and you find that even though there are cultural biases within different cultures, or
mhm.
they find that there's cultural relevance, that there are laws and legal processes that are reflecting the cultural conflict, but the values, still there are values that are so ingrained in you that even if you would like to just follow that common law way, or that modernization way, they're sort of
Mm.
like your blueprint. So in terms of implementation or actually practice, now that we have the knowledge, I think it's a balance, it's a dance, honestly. It's a dance. There are people who are so in it, there are people who actually do not subscribe to it. So it's a 50-50 kind of thing.
Yeah, because now if you look at it, even not only in Kenya but other sides of Africa, there's a problem. Even when you look at the court systems that are there, the courts that are in Africa, and you find, I think there is a disconnect between them as a people, as Africans, and the laws that are there, because these laws are like not theirs. They are not. They don't associate it with them, and you find they're in court and they're wondering how does that make sense, because at the end of the day, it doesn't make sense to them. So, what do you think is a solution there? What are the probable solutions that the people or the government or whoever can put in place to make sure that such kind of things become easier?
Thank you. Also, number one is the participation in the making process. Can we involve these indigenous communities in this legislative process, just to ensure that their knowledge and
Mm,
practices are maybe reflected to these new laws and policies? So, of course,
mm,
that can be achieved through consultations and inclusive, like, policy making reforms. But the funny thing is, these indigenous communities, for example, there's a time, I don't know if there's a finance bill that was put, and then the window to actually giving a report or trying to contribute to it was very, very short. And I was just like, is it that you didn't want people to participate, or what? So you find that these indigenous communities do not have access to, like, the internet or access to communication. They're so limited to a certain kind of people, unfortunately. But making them participate in lawmaking processes would actually work. Then the next thing is documentation, as we had said. It's
mm,
I would not say it's doable, but it would really work, in my opinion, where
mm,
these indigenous laws and practices should be there so that they can be preserved and just be referenced,
yeah.
just for reference, because they're there, but they're already butchered. So can they be, like, very well documented, and people get to know what is happening, and a judge 10 years later can refer to that and make a decision based on that.
Mm,
And then the other thing is integration of now alternative dispute resolution method. So can we
mm,
utilize this indigenous knowledge in this ADR, alternative dispute resolution methods, so that we can provide really relevant, something that is relevant and and involve mediators more, involve arbitrators more, and actually more solutions. So that one is more, that's what those are the things that I say can help, especially that one for participation, that one for public participation really work.
But even if they participate, some of these things we don't see them being taken into consideration. We saw what happened with the finance bill the other year. Right now, we are still in the public participation for the finance bill. So, how do you think that is going to happen? But it's something that we just. Do you think that the law is too far for Africans, because it's like a very abstract process? It's a very far. If I don't know if you get what I'm saying. It's kind of far for them, and it becomes a little bit closer for only those people who are educated. But you see, a majority of Kenyans and a majority of Africans are not learned, and even a few of us who are even learned are lawyers. So, is there a time in history that this thing will ever change, or it will always be the case? Always be the case.
Yes, I do agree with you vehemently that the idea of justice, the idea of law, um, it's very it's something that we are not there yet, and you'll see, especially when you see these cases in court, you can find their white collar cases. There are white collar cases, and we know the white collar lawyers that go for these white collar cases, and we know these other cases that just happen in the slums, for example, in the rural areas. So you know that we it's so far, the idea of justice is so far, and I can say this has come from let's say the judgments that are already made. For example, you might find that someone was not satisfied by a judgment, and they were like, so even if this didn't work out, then if this person was bribed, if this police, for example, was bribed, then what is the point? What is the point of following? So people shut their mind off, and they just don't want to know. They just want to look for other methods, because it will take more time, it will take more resources, and it's not even efficient. So I'd say people have maybe had the chance, but they have maybe been disappointed by the outcome. And for those who have not, there are those who literally do not know that there's something like justice, like you can go and actually get quick justice, because they just go to the chief, they just take their problems to the chief. But I think there's a time we are going to reach somewhere where the idea of justice will be redefined, and we try to move away from the Eurocentric approach, where it is a noble thing, it's a noble cause, it's for noble people. You can only have money for a lawyer. If you don't have a lawyer, that's it. I mean, I think it's time we start moving from there. And right now we have something called pro bono. Pro bono is where have lawyers or just law students, even like me, who go and give legal aid and legal awareness, and lawyers who take upon cases just for free and just do them for the purpose of society.
And it's hard for people to believe that, because the illusion that is there, lawyers really like money, and they are expensive, and their services are expensive. So I really hope that such kind of an effort should be embraced by people, and even the lawyers themselves can be able to do that, so that for the benefit of the society at the end of the day. Because somebody was saying that some lawyers actually benefit from the ignorance of the people. That's entirely their business. That's why they're there. So but eventually, I think if you are all learned in some manner, or informed, actually, I think the word is informed, it will be better. I can see comments coming in, and Gilbert Stark is saying that democracy has always been there, and it's working and functioning every day. The kind of democracy that we have is referred to as a hybrid democracy, and the electoral process is not about democracy. Okay, I think that's a different topic. And then we have Fred Bunkongo saying, Oshira, several things deter us from knowing what the law is and what it says. Number one, Africans don't read, we just accept things the way they are. For instance, how many Kenyans do you think have taken the time to read the Constitution? Okay. How many have read the finance bill? And then number two, Africans are just ignorant. That is why those who put just a little effort to read and have knowledge on law take advantage of us. We never want to know the truth or even take time to think. Grace, what are your reactions to these comments from Fredbon?
Interesting. Africans don't love to read, but it's one thing to take your constitution and read, and that's it. Let me tell you, when it comes to, have you ever heard when people say that when, let's say you have a traffic offense and a police officer comes and he tells you, by the way, you're on the wrong side and that's an offense, and you pull out your educated card, immediately, or my lawyer card. Let me pull my lawyer card. First of all, I know the Constitution, I've done constitutional law, and I start immediately saying, I know my rights, I know what this says. So I do agree that actually ignorance is what makes people take advantage of others, for sure. But it's one thing to know to read, and there's one thing to know how to apply it. Now in that process is where now you start saying, when ni mkubwa when ni mkubwa what makosa gani nimefanya, you see. And then because we have had cases where police officers actually do not like to be confronted or like to be told about that. So but that knowledge, you can use it to know the process and how that process works. And even when you go to court, for example, you know how the process works. So it's more of like conversations, because we can't just say, because the Constitution has a lot of loopholes and has a lot of weaknesses, as much as it was in 2010, and it was the renewed one. So it's more of having more of conversation and getting to know what are the trends that are happening and what are the new areas that are emerging. And yeah, but I basically think it's for sure we don't read, but we need to make it more. Why do I need to read? People need to understand, why do I need to read?
You see, I understand you, because okay, fine. I do know that Africans do not like to read, but I think it's also not fair for us to look at them in that aspect, because for them it was more of the information being shared to them, not and less of reading. Because you have to remember, there's still some aspects of the ancestors and the forefathers who are there that are incumbent in the people who are still alive today. You see, yes, indeed, we do not like to read. But what about how much information is being shared by the people who read? But I think also the best way, or the best question we should be asking ourselves: why should they read? I think that is the question that people ask themselves. Why should I read about this? Because now we are seeing issues, and the way you have just said, somebody removes my lawyer card, I know my rights, and how really do you how right now we have the Isaac Joroge's case that is in court. I don't want to talk much about it. The one who was assaulted the police officer. Yeah, Grace.
Yeah, and funny thing. Okay, that case, I'm really curious on how the outcome of it, because the charges, you won't believe the charges were robbery with violence. That is a capital offense, capable of putting you to more than 30 years in prison. You understand? And I'm just like, how? Like, what are the dynamics?
I did not know. I think he did not know, but ignorance is not defense.
Oh, okay, but I'm just saying what the context needs to be looked at very clearly, because those charges they're not very easy. They're not very light, and I'm just like, what could have happened? Because I later saw that the
Okay, I think you've lost Grace there one more time. I can see Fred Brukongo saying, we have no interest in research. Law is a whole research field, and we just accept things the way they are. We do not take time to research on what the law says or just go an extra mile to know law. That's true, Fred. And then he says, lastly, Oshira, it is time we stop using the word decolonization. Um, Everything thinks it's time we start a Afrocentric conversation on law and justice. That's interesting, by the way. I've never looked at it that way. Instead of talking about things that we need to decolonize, by the way, we need to the Afrocentric aspects of it. And he also says that we can continue being young in the name of we are colonized. We have to outgrow the notions rather of colonization and our own and own our story of law and justice. True. That's really true. I can see, I don't know, just a minute. We see Grace. We put Grace back in. Yeah, Grace, you're back. You can hear us?
Yes, I can hear you. Yeah.
Yeah. So I was reading some comments here from Fred. I think let's see what is going on here. Grace, are you there?
Yes, I'm here.
Yeah, go ahead. Go ahead. You're saying something.
Yeah. So before I finish, I was like, so you see that type of ignorance. I was saying, I'm not sure how true this is, but I heard that the the police officer who was attacked they sort of like agreed to the apology or accepted the apology of the young man. But I'm already
Mm,
like, it's already under the law. This guy was
mm,
taken to court. He's 19. His lawyer was saying that he's 19, but the policemen that brought him were 21, more than his age. But I'm just like, why? Like, it can happen in a flash, it can happen in a bit of a second.
mm,
And all of a sudden, you have very huge charges, and you don't know, like, you don't know how it came to be there. Because I'm yet to read like the real facts, because of course there's a lot going on social media. But
mm.
there's so much ignorance there, and on both sides. Well, that's a debatable
Yeah, that's a debate. Yeah, that's true. I
because you also
yeah,
have cases where the police now are the ones that are doing these bad things to citizens, and maybe nothing is happening. You see, it's
yeah.
happening. So
Mm,
it's something. It's a two coin side.
mm,
So
mm. Yeah. Yeah, that's true. That's true. So let us talk about the last thing that I'd like us to talk about out in our conversation, and it's the rights issue. You know, we have talked about the legal frameworks. You've talked about, and Fred Burn is telling us, it is high time we stop using this decolonizing term. And I actually think that's an interesting thought there, and talk about more of what we want to. Afrocentric conversations rather than saying decolonizing, we say Afronizing, if that's how. Anyway, so Grace, let us talk about rights. And for example, in the African setup, I think the rights do not differ as much as what are in the Eurocentric uh, setup, but there is some difference. There's a lot of difference in the context. So, do you think that it is high time then we also consider we Afronize our Africanize, I don't know what is the best word, the rights, the rights that we have in our country. Yes, we know the rights, that the Bill of Rights are there in the Constitution, but how more than or rights are just rights, they are just universal, and there is nothing like Afrocentric rights. What is your whole what are you thinking about that whole issue, about rights? Do we need to have African rights that are special also? Do we need to consider that? Do we just say rights are just rights and they're universal? What are your thoughts?
that's an interesting one. So we do understand that we're evolving as a generation. Rights, customary rights right now, they are not the
Mm,
African rights 10 years ago, 20 years ago, 30 years ago. You understand? They are
mm,
different. So we
mm,
might think that we are Afronizing, or what's the word? Afro? Because now Fred has said we use, okay. So we might think that this is the route we are taking, we have a Eurocentric approach, but
mhm,
the thing is, it's ever evolving, and we can't have a standard, because the thing is, when you go to Uganda, for example, or you go to, let's say, the other side of the continent, like Asia, for example, and your right to life is denied, or your right to healthcare is denied, if at all they go by now the right to healthcare in an Afrocentric manner, you understand, and find that this Afrocentric manner is not of quality, for example, and you have gone to a different where their right to health is so quality, it's discrimination. We'll call it discrimination, because a place where there's quality education, there's quality health, then us we want to bring Afrocentric type of rights. So we can't really. It's a good approach in terms of just individual persons per se, or in the small capacities we are. But I think we still stick to the universal kind of it, because a lot is happening in the world, and I feel like if at all we are supposed to group them, one has more power at the end of the day. And that's just where we are. We are evolving. The customs that we have right now, they're so different.
Okay.
Yeah.
Okay. Thank you, Grace. I like us to stop at that, because I think we have had an interesting conversation here. It's something that I think we have started a conversation that many people had not looked at it, because we talk about decolonizing, or this Africanizing of cultures, of ways of life, of behaviors, but many a times we overlook the legal things, the legal frameworks, and so on and so forth. I think this is a conversation that we should have another time again. We get deeper into the details and see how what comes out of it. But I like to appreciate everybody who has watched us live, and everybody who will watch later, and also Grace in a special manner for sparing your time to come here. Grace, any last words before we wrap it up?
Thank you. So my last words would be, let's try and get to learn, or get to be curious, get to ask questions, and question the status quo at the end of the day. Yes, let's get to be curious and just not settle for less, as we try to take this Afrocentric approach in everything that we are doing. Other than that, thank you for inviting me.
Thank you, Grace. We will plan another conversation, so that we can come back and have get deeper into this conversation, because I think it is something that is of interest to everybody here in the continent, and even here specifically in Kenya. Apart from that, I want to wish everybody a good time. My name is Mutadhiwa Shirawanyaga. Ishinegera Nashia Mobi Mubodi. Good night.
Good night.